Does call the case, People versus Cameron Larry.
Good morning, Your Honor. Ray House, Assistant State Attorney for the people.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. Larry. Mr. Larry, could you aim for the judge?
Cameron Larry.
Your Honor, it's the date and time for a bond hearing requested by the defense. Leading up to that, I had an opportunity to negotiate with the people. I believe we have reached a resolution. Mr. Larry has executed an advice of rights. I've provided the plea form along with the advice of rights signed by my client to the court.
All right. Court, the plea form indicates that the defendant would be pleading to added count 3 of aggravated domestic violence, the 1-year offense. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. Defendant is also agreeing to attend Accountable Choices, the 52-week level 3 program, and rest on all counts, if any. There's also an agreement that the prosecutor will recommend sentencing under 7694A. That's the court's full understanding.
And that's our full understanding. Thank you, Your Honor.
May I have him sworn?
You solemnly sworn to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Sir.
State your name, please.
Cameron Larry.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of aggravated domestic violence. That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that?
I do, Your Honor.
All right. Do you understand what a no contest plea is?
I do, Your Honor.
All right. 2 things about it I have to make sure that you. And the first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
I do, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court will treat you as pled guilty. You understand that? You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Your Honor.
All right. Basis no contest plea.
Potential civil liability, Your Honor.
Sir, to the charge of aggravated domestic violence, how do you plead?
No contest.
You understand that by pleading no contest, you will not have a trial of any kind. You're doing this voluntarily and of your own free will. Court has been provided and has reached Washington County Sheriff's Office report for their case number 2620178. Any objection from either party to the court having reviewed that report?
No, just
None from the defense, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if between the time of my acceptance of your plea and your time of sentencing, if you commit misconduct as defined by the Michigan court rules, not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that? You do?
Sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
now, Your Honor.
None from the defense.
And have I complied with the court rule?
Most satisfied.
Defense is satisfied.
Court will accept the defendant's plea of no contest to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14 probation. Sentencing will be June 15, 2026, 10 a.m. before Judge Washington. And maybe we can deal with motion to reconsider, but we can deal with the bond issue.
Thank you, Your Honor. And I very much appreciate the court accommodating this hearing. I think Mr. Larry's very appreciative of that as well, because when we were last before the court on May 19th, when Mr. Larry was remanded, the reason he was remanded was for the contents of the phone calls that were at that time revealed to the court and provided what the people believed to be an adequate basis for forfeiture by wrongdoing and potential witness tampering felony charges. I spoke to Mr. Larry about those issues that arise from it and how that not only would impact his case, but potentially the outcome of this entire proceeding and his potential of additional time in custody. Those things are not just a violation of the court's orders, but there's a reason we have those rules, and it is to protect the parties and the witnesses and really the integrity of the entire system. And, when I talked to Mr. Larry about that, I think he understands how serious it is. And we're before you today to ask this court to reconsider the determination that was made on May 19th. We're asking that the court considers reinstating home confinement. And, at the time that I initially asked the court to continue his bond, I know I talked heavily about the family support that Mr. Larry has. And, in the discussions I've had with him since then, I talked to Mr. Larry about, it's rare that I see that kind of family support among my clients. And, I have clients who maybe they start with that kind of family support, but as they appear more and more times before the court, it goes away. And I don't think he ever wants to be in that position. And, he doesn't want to burn those bridges. I think he's, if not before, come to appreciate that his parents are so involved because they care about him. In the time that Mr. Larry was out of custody between April 2nd and May 7th, he submitted 4 job applications while he was on home confinement. And I apprised the court that he, wanted to enroll in community college, but that's not exactly a remote goal. It's something he was scheduled for orientation on April 3rd, and subsequently violated the court's orders, got himself put into custody on April 2nd. So he's taken serious steps towards bettering himself. I think that the 52-week program that our agreement contemplates is something that will benefit Mr. Larry and make it so that he is not a person who comes back before this court. And hopefully this is the turning point in his life. The agreement here is a considerable reduction. And Mr. Larry understands that there are no felony charges anymore, but he has an opportunity to keep his criminal record clean at this point if he complies with the terms and conditions that are imposed on him by the sentencing court. I'm asking the court to consider allowing him to return to home confinement and establish a period of compliance prior to sentencing in the 14B district, so that at the time of sentencing, when the court's considering the people's sentencing recommendation to 4A, he has a period of compliance and he can present himself as a good candidate for probation. Your Honor, a couple changes to the motion that I would just like to put on the record. In paragraph 3, I said the bond was posted by Mr. Larry's parents. I should have written family members.
Yes.
In paragraph 21, I said, in addition to the orders I listed, a GPS hot zone tether, I conflated that with home confinement.
Yes.
But thank you, Your Honor.
Your Honor, and Your Honor, first of all, people didn't respond via motion response. One, because this was a pretty quickly set, but more importantly, I didn't see anything additional in the motion, because the motion to reconsider. And our objection would be based on all the reasons that were put on the record when we were here Tuesday. Your Honor, I will say, as counsel indicated, this is a significant reduction. Us not moving forward with felony charges of witness tampering. Is not something that is commonly done when someone tries to interfere with the integrity of the criminal process. The reason we take these things seriously is because not only do we here have a victim of the assault that took place by Mr. Larry, we then have a victim, which is the whole court system as a procedure. The right to go through this process is a sacred right. And by no means, when we say accountability, do we mean that everyone has to be guilty or no contest, branch or conviction. we do mean that they have to take accountability and follow the process. And unlike the victim of his assault, the court system is not so easily coerced or bullied. So that is all really important for Mr. Larry to know moving forward. The reason for the reduction in large part is because defense counsel, the court have taken this seriously. I have full faith with the counsel and the court that Mr. Larry will be properly informed about the consequences if he does choose to continue violating the rules, the laws, and the conditions that were put in place. With that, though, also comes great responsibility on his part to make sure that now that he's been given this chance, now that he has been fully informed of the consequences of the actions, he chooses to do the right thing. Based on his age and lack of criminal history, opportunity at this stage, it was done early enough before we dwell deeper into the witness tampering investigation. And it's really his opportunity to really change the outcome of his life moving forward. With all of that, Your Honor, I'm going to leave to court's discretion regarding the motion. The court is not only aware of this case and the factors that would play into it, but also very aware of the dynamics that go into these types of cases. The court also knows my position on these types of cases.
All right. Larry?
Your Honor.
Why do you think I was so angry with you?
Because I kept digging myself a bigger and bigger hole.
Is what?
I kept digging myself a bigger and bigger hole when I could have just.
Yeah, there's that. But, you know, your family, I didn't know at the time, but they was I think your siblings that posted this bond. And I'm looking at it and I'm thinking to myself, I didn't want, because you came initially before being in custody, I didn't want them to lose that. I felt you had enough family support out there that you could do the right thing. The problem was I didn't know everything that had happened. Young man, you were messing with fire in ways that, quite frankly, you don't even understand by doing what you did. When you find yourself in a position like this, it is no time to try to play around and think that somehow or another you're going to be able to do something that's going to manipulate the system. You hear me?
I understand, Your Honor.
And if you think I don't put up with it, I'm going to tell you right now, you're going before Judge Washington. She is not going to tolerate it, not one bit. So I'm going to suggest to you that you toe the line. I'll say also this, because sometimes it's said that a son can maybe pay for the sins of his father, but I'm not going to do that to you. Because what your dad did,
Yeah, high temper.
if I were, I'd keep you locked up. No one ever goes out of this courtroom that way. And if he doesn't hear it somehow or another, you can let him know that. All right. And to let him know that I am at least somewhat forgiving. Okay. What I'm going to do is previous bond to $10,000 that's already been posted. 10% that's already been posted. All the previous bond conditions, including the home confinement tether, is reinstated. Okay.
Your Honor.
You.
Your Honor.
I'm sorry before we leave. I remind you that it's obviously Mr. Larry is aware that he has to contact the victim, that also family members or friends are not to contact them.
You understand that, young man? And so I expect you to abide by that one. If nothing else, I hope you learn that from this. All right. You might want to just tell your father that too. Okay. Thank you. Court. I'm fine.
In this busy court session, Judge Simpson handled multiple cases ranging from bond hearings and adjournments to sovereign citizen-style immunity claims. The judge balanced efficiency with fairness, revoking bonds when necessary and ordering competency evaluations where appropriate. A perfect snapshot of what real court dockets look like every day. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.